Welcome back to another episode of Top Attorneys of North America podcast. Today, we're talking with a true master of the courtroom, Stephen LaBriola, founding partner at Fellows LaBriola LLP in Atlanta, Georgia. Stephen is one of those rare trial lawyers who's equally comfortable handling bet the company commercial disputes and catastrophic injury cases that change lives. He has earned a reputation for his tenacity and for always aggressively pursuing the most favorable outcome possible for his clients. Stephen, it's a real pleasure to have you here today. Thank you so much for joining us.
Thank you. It's an honor to be here with you and to chat about something I enjoy and do each day.
Yeah, I always hear you say it's a labor of love.
It is, yes.
Okay,
It
so
would be hard to do it otherwise.
okay, so let's start at the beginning. I know you went to law school in my neck of the woods, NYU Law School, graduating in 85. You then served as a law clerk on the Colorado Supreme Court before working as deputy district attorney in Denver. What drew you to trial work early on, and how did your time as a prosecutor shape your later approach as a civil litigator?
That's a great question. I think my family, none of whom are attorneys, used to say that I enjoyed arguing, and so they always thought that I would and should go into the practice of law. The truth about the practice of law is that very few attorneys ever try cases. Most of them are in their offices and doing transactional work, or if they do litigation, they still are not in trying the case at the end. You asked the question about what impact did being a prosecutor have on me. I think it's that early on, I was in the courtroom every day and trying cases when the work I was doing was probably over my head. And by that, I mean you learn how to try cases through, you prepare, you have others that are teaching you, but there's nothing like the school of hard knocks and nothing like having public humiliation as the greatest teacher ever. And so when you're a young lawyer and you're a prosecutor, they don't put you on the biggest case when you first start. And when you're in, you're going to make mistakes. And I made a bunch of mistakes early on. And it's from those mistakes that I learned how do you go about trying to connect to a jury? How do you put together evidence? What are the rules of evidence? How do you structure a case? How do you structure witnesses? All of those things. And if I had not been a prosecutor early on, I simply wouldn't have had the opportunity to get in the courtroom. So I look at that experience and then my clerkship at the highest level in Colorado is a great experience because I knew what the justices needed to see in a record. So I learned how to protect a record and how to create a record so that if the trial court judge makes a mistake, you have the ability to reverse the judge on appeal.
Yes, sir. Yes, sir. And I know that you have worked with some very large companies, Disney Plus, Hulu, OpenAI. But I know you're making a shift towards catastrophic injuries or families dealing with wrongful death. Often, these are cases that other firms might turn down. When you're evaluating a case, what makes you say, yes, this one's worth going all in on?
It's a combination of events. One, it has to be catastrophic, and by catastrophic, it's either a death case or it is a permanent injury that is life altering. So it can be a catastrophic burn, it can be a spinal injury, it can be a brain injury, it can be the loss of limbs, quadriplegia, paraplegia. That's that's where we start. So that's the first part of it. In other words, we don't do fender bender cases. I refer those out and don't handle those. Then, secondly, you look to determine, am I going to be able to obtain a recovery that is commensurate with the loss? And by recovery, you have to look and say, is the insurance either structured in a way that will um, have a meaningful recovery, or is the entity that is behind the cause of the injury financially well heeled so that if you obtain that uh, gigantic verdict, you have the ability to go collect it. And so there are a number of things you look at there. So if it were, for example, a tractor trailer truck, many companies structure their company so that they try to minimize or limit what a recovery can be when it can be collected. And so they will set up literally hundreds of LLCs and have only um, a truck or two within the LLC, or they will quote unquote contract out. So if you look at any of the big delivery companies, those that come to mind, the Amazons, the FedExes, the DHLs, et cetera, they will contract out with what I call mom and pop companies. And then they will have an agreement with that mom and pop company to obtain insurance coverage on their own, and then they will try and isolate it. And so you have to know how to pierce through that, how to be able to show that there's agency between the underlying entity, LLC, or small company, and the bigger company. And you've got to be able to know how to get the discovery to make a meaningful recovery from that. And when you say I've made in making the switch, that actually has happened kind of organically over the span of a 25-year period. It's just now become a much more significant portion of my practice that I'm looking to say I may look to do this full time and kind of push aside the other matters because I find it so much more meaningful to be working on a matter and help a party or a family that's truly in need.
Yes, sir. Interesting. And your bio emphasizes that one of the major contributors to your success is your ability to convey that story to the jury. Let's talk about jury selection for a moment, the art and science of picking a jury. You've been in front of a lot of juries over the years. How do you approach voir dire? Are you reading body language and intuition, or do you have a more structured way of figuring out who's going to connect with your client's story?
The first thing I would say is it's a credibility battle. The entire trial is a credibility battle with the jury. I think any sticky things with the jury don't work. So I leave all of the canned stuff outside of the courtroom. I try and speak from the heart. I try and speak directly to them. I'm looking to do a number of things with the actual questioning of jurors, but it begins long before you go into to start the jury that day. It begins by looking to trying to determine who might be good jurors on your case and what are issues that would be touchstone issues that could harm your case. And it's really looking for bias within jurors. As I mentioned, I'm a former prosecutor. I've got four kids, three of whom are daughters. And as a prosecutor, I've dealt with really tough cases in my early career of dealing with, say, child molestation and those kinds of things. And if I were asked to be a juror and sit on a child molestation case, I'd probably have a pretty strong bias internally. It's not that I wouldn't try and put it aside and be fair, but I would internally have a pretty strong bias against that type of case. Well, in a personal injury case, there are a lot of people who have biases against that type of case for a whole host of reasons, many of which deal with just driving on the highway. You see billboard after billboard saying, get the money you deserve, things that are triggering. And you'll have chiropractic groups that are advertising and all sorts of things that give this distasteful um, aftermath in your mouth of, these are people who are faking. These are people who are looking to try and get something for nothing. And so you've got to recognize that that's a big issue in these cases, and then try and invite jurors to talk about that, to be expressive about it. And so one of the things I like to do, if the court will allow it, and every judge And if it's federal court, it'll be very different than state court, but every judge does voir dire a little bit differently. So the first step is you've got to know, how does that judge do voir dire? One of the ways to learn real fast is go pick up the phone, find out if the judge is also doing criminal work, call down to the prosecutor's office, find out who is a prosecutor who's been in trying a case. Now, they're going to do criminal voir dire a little bit differently than civil, but you want to find out who has tried a case in front of this judge recently and how do they do it. Do they have all of the members sitting in the courtroom and you do a big general voir dire first? Do they allow specific questions at the same time that they're doing general questions, et cetera? The other area we've done is I have created juror questionnaires, very short juror questionnaires. I run it past the opposing counsel ahead of time. We bring clipboards with pens so that the court, can look and say, hey, judge, this is going to speed up voir dire. And they're designed to try and find out, how do people think about various issues. So if it were um, a motor vehicle wrongful death case, you'd want to know whether people have strong feelings one way or the other pertaining to personal injury cases. You want to know whether they would have an aversion to awarding a large sum of money. Whole host of things that you have on a questionnaire where they're just checking a box, yes, no, yes, no. That allows you to very quickly look and determine who are the people you want to try and ask them to tell you more about that. Secondly, I put together and request the court to allow each side to make a very short 1 minute mini opening. And the mini opening is designed to be non-argumentative and to simply let the jury know what is the big picture that this case is about. And so if it's a case that's a medical malpractice case, you may find that there are people who look and say, medical malpractice cases are destroying the health system in America, and they're completely opposed to it. You'll have other people that will say, I think it's a good thing. It helps make medicine safer, and it has improved everybody's lives over time. Those are things you want to know one way or the other. And so having a short mini opening then allows you after that to turn to the jury and say, now that you've heard a mini opening, you haven't heard any of the evidence in this case. Who here would say, and I usually then excuse my client. And I excuse my client because I want the jury to be brutally honest. And they have a hard time doing that if the client is sitting there in the courtroom. And so I will then turn and say, now that, the family member or the person has been wheeled out or removed from the courtroom, I'd like to have you give your honest opinions. And having heard this mini opening with no evidence, how many of you would say that we've got a strike against us? And then you'll get a whole host of people who will raise their number. And most judges now are not having you identify the jurors by name, because they want to have some form of anonymity for the jurors and give them that kind of sense of comfort that they're just a number that they can sit and answer truthfully where they are. From there, it's a discussion. And there may be somebody who gives an opinion, and I will ask how many other jurors agree with juror number X. And when they tell me something, I'll turn in and instead of trying to try my case in front of the jury, what I really want to do is get people to identify their biases that they have. And some people can say that they have a feeling against something, but it's not a strong feeling. Others will have super strong feelings. If you say how many people have strong feelings against personal injury cases and they raise their hand, and you'd say between 1 and 10, and this would be just the people who have feelings against, tell me what your feelings are. And they'll say 11. Well, that's a person you want to know a little bit more about, and you'll ask them to explain it. And I have learned through the years that you don't have to worry about cross-contamination between jurors. It's just like in the political realm, somebody who's going to be a strong supporter of one candidate can hear a person who's a strong supporter of the other candidate, and it's not going to switch their opinion. in that course of just hearing them. I used to think it would, but the studies have all shown it doesn't. And then it's really just trying to have an open and honest discussion with them, make sure that you never get over your skis. And by that, I mean, do not appear to be um, someone who is trying to manipulate the jury. They have strong felt opinions. Some of them are scared. You want to try and make it a open environment where they can share their opinions so that you can determine whether this is the appropriate person to have on your jury.
Yes, sir. Yes, sir. And I know when you work with catastrophic injury cases, they can be deeply emotional for the family, yourself included. And I did hear through the grapevine that you recently settled a case in, I believe it was a trucking accident. You said, um, how do you handle the family's emotion? How do you handle your own emotion, especially in these um, deeply emotional cases?
Well, the first question I ask of the family is how do they want me to communicate with them, and what type of information do they want me to communicate with them? Because I will learn things that they may not ever want to know. I will obtain the autopsy. I will have photographs from the scene many times. Some people, if you were to look at how is a funeral done, some people want a closed casket and they do not want to see their loved one in the casket, even if there was no massive head trauma. They simply want to remember them as they were when they were alive. And so you've got to be cognizant of that. I had one client, and we had a video that captured the immediate aftermath of the impact, and he did not want to see it. And we got to a point, because it was contested liability, where I told the client that um, unless he saw the video that showed the aftermath of the impact, because it all dealt with lighting, what were the lighting conditions like, that he would not be able to make an intelligent decision on whether to accept an offer or not accept an offer, or whether to go to trial and what the risks were. And so that was one that had to have a lot of conversation about it. Another area, for instance, you mentioned the case that just resolved, and it did for a, you know, uh, uh, multiple millions and millions of dollars. And two uh, wonderful young, a young man and a young woman in their early 20s. One had just been, actually probably in his late teens at the time. He had just been put in as a freshman at Georgia Tech. The daughter was going into her sophomore year at Kennesaw State, so very young, and their dad was killed. When that matter resolved, I knew that the day that the payments were all being transferred out, that was going to be a really hard day for them. And I reached out to them to say, look, I know that, it's very trite to say money can't replace human life, but it is very true. It cannot. And the money they're receiving is a legal proceeding. It's a conclusion of a legal proceeding. It does not reflect the value of what their father meant to them. And I expressed that to them, and it was very meaningful. In fact, they have asked when I was next going to be in the office, and I told them today. So whether that means they're coming by, I don't know, but I hope they do. It was each of these cases, I take them personally because I get to know the people, and I'm working to try and bring about the best recovery I can for them from a legal standpoint. But there's a lot of emotions that come up in all of these cases. There is also something very beneficial to having a trial, but the trials can be gut-wrenching for them as well because the defense is doing everything they can to try and minimize what that jury comes back with, or to try and point the blame at the person who has died, the person who's been injured. So all of that is very difficult, and you have to in many ways become a counselor. And by counselor, I don't really mean a legal counselor. It's more of a mental counselor. And if the issue arises to the circumstance where you turn and say, this is beyond my capability, I will very frequently reach out to try and encourage them to get mental counseling and to get that kind of help.
Yes, sir. I can imagine that it's very tough. Like you said, I wouldn't trade a family member for a settlement in any situation. And to go back to something you said earlier, you mentioned billboard attorneys. So I have to imagine that clients have almost a misconception that in a week's time or 2 weeks' time, I'm going to get a six-figure or a seven-figure settlement. How do you manage your clients' expectations when it comes to cases, especially like catastrophic injury cases?
It's through good communication. It's letting them know what needs to be done on the front end. I mean, immediately, what needs to be done is preservation of evidence. And preservation of evidence has to happen as fast after a collision as possible. In any large truck injury case, truck crash case, the defense is already out there that evening. They may be out there at the same time the police are still removing matters from the scene. And they're contacting and interviewing people, and they're taking all sorts of steps to try and assess whether they have a defense, and if they don't, what does the case look like from their standpoint. From the plaintiff's standpoint, they're not thinking about that. They're trying to survive in a hospital. They're trying to, um, just move forward. And then they start getting bombarded. And I did not appreciate this until my spouse had had a minor fender bender, and we got probably 20 solicitations from runners trying to solicit their services. And it is illegal, it's improper, but it happens. And because it happens, you have people who have these expectations that the matter should get done quickly. In a large case, you're going to need expert witnesses. And the expert witnesses are not just on the reconstruction side of putting the case together. The experts are going to be on the damages side. And by the damages side, I mean they are going to include um, life care planners. They're going to include economists. They're going to include people to help put together what is the loss of household services. If you have somebody who has been turned into a paraplegic or quadriplegic, the best analogy you can give is if somebody played a sport and they got injured, and say their left arm had to be put in a sling and they had to wear a sling for 2 weeks. Well, during that 2 weeks, there are a whole host of things where they had just taken their left arm for granted. And if it was their dominant arm, and say they were right-handed and it's the right hand, they can't open a jar of pickles. It's a whole host of things that they start to look at. Well, just compound that. Take that to somebody who is now quadriplegic. That person can't do their checkbooks. They can't go to the bathroom on their own. They can't get in or out of bed on their own. They can't take medications on their own. They can't move on their own. They are totally reliant. And that spectrum from just your sling to the quadriplegic, um, there is a way to quantify that. And that way to quantify it involves expert testimony. All of that takes time. The other side is going to hire their own experts. The court in any catastrophic case is going to say that there's going to be a year of discovery at a minimum. And then you have to try and get on court calendars, and they're busy. These judges have got, hundreds and hundreds of cases that are in the queue in their docket. And It's not until those matters get placed on a jury trial calendar, but they can only try so many cases at once. So you have to have that communication with the clients on the front end to let them know, hey, this may take some time, and that can be frustrating for them.
Uh, and I have to say, every interaction that I have had with you, you have always presented with a calm demeanor. You're also known for being incredibly calm in the courtroom, steady, unflappable, even when the stakes are sky high. Uh, is that just your personality, or is it something you've worked on over time? And be honest with me, do you ever get angry or fired up during a case? Do you really keep that even keel all the way through?
I will get very fired up if I think that someone is trying to pull a fast one. And so if there is somebody who has attempted to try and make something appear other than it is, I will get very hot very quickly. Uh, Judges don't like that. And so it's a combination between uh, um, becoming very hot in terms of the issue, and then also making sure that the court can maintain decorum in a courtroom. Uh, I have also learned over time, when I was much younger, I would get hot quicker. And I learned that you have to have the jury give you permission. And by permission, it means that they tend to initially associate with the person who's on the witness stand because they're nervous, unless it's an expert. Some experts, you can just tell they're very sure of themselves, very cocky. They have no nervousness at all. But most witnesses who are on the jury stand are nervous. And if you just come in like, a fireball, on this person who is nervous on the stand, jury's not going to like the way in which you did it. So if you have a witness, for example, who has just given a false statement on the stand, or they pretend they can't recall something, you have to then take it in steps. And before the fire can come out of you, you have to have that jury let that person and let you see that person, try to mislead the jury. And you have to give them an opportunity to try and fix it. And by that, you can have very carefully crafted statements. And if they then overstep the bounds, after they've done that a couple of times, then you can lay into them. And up until that point, you run the risk of having the jury turn on you. But I had a case, this is a business case. It was an accounting malpractice case. And if you were to turn and say, how do I like to try and go about examining a witness and cross-examination? It's through very careful visual steps. I look at it kind of like radio. And so this was a case in which husband dies. He had run a business, very successful business. The business was continuing on. There were a whole host of employees, and suddenly the widow was going to have to step into this business. At the funeral, these accountants who had done the personal tax work for the husband, but not the business work for the husband, um, literally gave her a business card in the funeral recession line in front of her husband and said, give us a call when the time is right. We can help you. We've done his tax work, and you're going to need help. Then they went into the business afterwards and got her to sign powers of attorney and give her the authority, or give them the authority to, in essence, run payroll, do all of the quarterly filings, to do the in filings. Well, they were not competent. One of them had been a defrocked CPA, had lost his license. And so when they began getting IRS notices because they weren't doing things properly, they did not provide that to the widow. And instead, they began using company funds to pay for those matters, and then they self-enriched. Well, just during the trial, uh, I then walked through a series of storyboards, if you would. And the storyboard was, when you first met Mrs. X, it was at the funeral of her husband, correct? And then you talk about, in fact, you were in the line and she had an open casket. So when you spoke with her, her husband was literally in the casket that was open, right? Yes. And then you gave a business card to her, correct? Yes. And when you gave her the business card, you said that you had done the tax work, right? But you had never done the tax work for the company. So you didn't tell her that though, did you? And then it was just kind of a walking through matters. And when you were talking to her, she had mascara running down her face, right? It's all of the things that lets a jury visually see what they did. It's not done in a mean, aggressive manner. You're not saying shame of yourself for doing this. Let the jury come to that conclusion. And I have found over the years that that's a much more successful way to aggressively cross-examine someone than it is to be fire and brimstone and jump all over them. If you've got little facts and you can walk them through and make it visual, uh, you will get rewarded by the jury's ire against the defendant, much more so than if you flail your arms around and scream and yell.
Perfect. I find that extremely interesting. Definitely words of wisdom for other trial attorneys, and for our younger attorneys aspiring to do trial work, especially in complex litigation or catastrophic injury. What habits, training, or mentorship would you say are essential?
The first one is hard work. There's just no substitute for it. Um, you can come back and say, "Gosh, that was just a brilliant cross examination," and people will think that was just done off the cuff. When the truth will be that it was done with hours and hours, if not weeks, of preparation on how to go about doing the cross examination of a particular party or the structuring of a case. So it is trying to sit back and I look at a case on the front end and say, if I'm going to lose this case, how am I going to lose it? And I will start thinking about that from the vantage point of my adversary. And I think that is a really important step to take because we are in an adversarial process. It is not one where you just put together your case and go, whoopee, we did a great job. So, for example, if you were thinking about an opening statement, in an opening statement, if all you do is you put up the evidence that you're going to show to prove your case, and you then turn and say, if you're allowed, it depends upon each state has different rules. If you're allowed to talk about an amount or how you do that, et cetera. But then you go sit down and they take a break and everybody's high-fiving in the bathroom, what a great job you did. Well, you then go back and sit in the courtroom. You've not thought about what is the defense going to do. Well, they're going to stand up and they're going to say, you know what, Mr. LaBriola didn't tell you. He didn't tell you about X or Y or Z. At which point the jury's kind of looking over at you like, yeah, why didn't you tell me? Is that true? And of course you're sitting there going, well, they've taken that out of context. I'm going to be able to pull that up when I get to my case and come in. Well, fact of the matter is you probably have lost that case. You probably lost that case at that point. And so what you've got to do is you've got to sit back and say, if I'm going to lose this case, how am I going to lose it? And then you need to sit back and identify all of those areas and then say, wait a second, why am I still going to win this case, notwithstanding these bad facts? You've got to then bring those facts up, not just in your opening, but throughout your case. And you've got to be able to put them in context. So if you have, for instance, a medical malpractice case, they're going to have an informed consent docket, sheet that the patient signed. And you'll have one where I've got a patient who went in and had nasal surgery, and the doctor drilled through his right eye muscle. Well, if you go to the informed consent form, uh, it has a provision on there that's, I mean, it'll say everything. It'll say your risk includes death, so they'll all be bad. One of them will say you can have injury to your eye, okay, or injury to your brain. Well, to me, you turn and say, if you don't bring that up, the other side's going to say, this patient, before he went into the surgery, was told that his eye could be injured. Look at this form, and they'll pull it up. And that'll be the first thing that they pull up. Well, in a case like that, you get that form and you blow it up. You bring it to gigantic size. And then you put it up, and when you get to that point and you say, shortly, ladies and gentlemen, I'm going to sit down. But before I sit down, um, the defense is going to have an opportunity to stand up. And because we've gone through discovery, I have a pretty good sense in terms of what the defense evidence they're going to want to talk to you about. So I'm going to talk to you a little bit about that, and let's put it in context. You'll say one of these documents is this informed consent form. So to make matters worse, this injury that happened to our client is so foreseeable that they put it on a form. And here it is right here. But instead of carefully going about the procedure and going around this area, the doctor just went through with a microdebrider, drilled right through his right eye muscle, like a bull in a china shop. Well, at that point, you've helped deflate it. And then you just leave your board up there. So you talk about the bad evidence and you've turned it into your evidence. So I don't know if that helps answer your question in terms of what advice do you give, but it's really thinking hard about your case and about all the ways in which the defense is going to try and, either lower the value or cause a jury to say, hey, I've got enough doubts in my mind that you have not satisfied your burden.
Yeah, you answered it perfectly. Do you allow, you obviously have a wealth of wisdom. Do you allow younger attorneys to shadow you during trials or during your cases?
We have a team, and each person has their own roles. I will turn at this point. I'm turning largely to other attorneys to say, I want you to handle the motions in limine. I want you to handle objections. We will have appellate counsel that comes with us to trial. So if we have a sidebar, some judges don't allow more than one attorney to come up during sidebar, but I typically will let the judge know, Judge, we've got our appellate counsel here. So I would like to have appellate counsel come with me. Um, if the attorney is truly younger, they're not going to be examining witnesses. They're largely going to be in that role where you're turning to say, hey, here's a legal issue that's come up. I need research on it, et cetera. As they start to mature, then you look to say, where's a witness where the testimony is not quite so earth shattering, and I'll have that attorney handle a witness or two. But I tend to really believe that the best learning process for younger attorneys is to have them think about how would they do it, and then look and see how do I do it. But it's give and take. We have very smart people who are working with us. We have federal law clerks, former federal law clerks, or we have attorneys who have come from, the biggest and best firms where they've been out for a couple of years, and then they look and determine that that's not the kind of practice that they want to do, and they come over to our firm. So it is with respect to their brain and to their capabilities, but also just appreciating that hard knocks lesson. You've just got to go through it first. And until you've done it, you can show, I know how to think quickly on my feet when matters pop up. And I've done the homework, not just to the extent of I'm competent, but to the extent of I know this case better than anybody else. You can earn your way into a role within a trial, but it's not just given.
Yes, sir. You mentioned your wife earlier, so I know that family is very important to you. you've balanced a demanding trial practice with family life. Can you share how you've managed work-life integration? And is there any advice that you have for attorneys striving for both professional excellence and personal fulfillment?
Well, my wife is a former geologist, so she's not an attorney. And, with four kids, she spent an awful lot of time
Mm,
helping to raise them. Um, and what I guess I've learned for me, every marriage is going to be different. I certainly can talk a little bit about my cases, but I try to leave my work in the office when I'm home. Years ago, when I was a prosecutor, I would have my wife sit on a couch and I would give my opening statement to her, and she would then start to live the case and get nervous for me, et cetera. And then as time progressed, I learned it's better probably for a marriage for me to have others doing that. Um, no, it's it- it- you know, we've been married for an awfully long time now. It will be 30. Well, we've just had our 37th anniversary. So
wow.
we've been together for a long time, and she knows when I've got a trial coming up. I start living it a little bit more when I'm at home, and you know, when that trial's done, there's a great amount of relief that occurs, particularly if you feel that you've done your best, if you've laid it all out on the line and you've done your best. Um, so it's really just kind of that internal support and having her appreciate what it takes to try a case. I can remember many years ago when she came into I think it was just arraignments that were happening in a criminal case, and the defendant in that case was about 7'3". He was just huge, and I can't remember what he had done, but he had the leg shackles and the hand shackles, and I was standing next to him, and I'm 5'11" or so, but I look like a little dwarf next to this guy, and it made her she afterwards was like, gosh, doesn't that make you scared or concerned? And I think the person likely had a substance abuse problem, and so if he had been drunk or on his substances, then the answer would be yes. But he was actually quite docile, notwithstanding how gigantic he was. Plus, there were armed marshals who were right nearby. So um, you know just an example of when your spouse kind of turns and says, "Oh, gee, that's what you. How was your day in the office today?" It's a little bit different.
I love it. Congratulations on the 37 years. Um, if you could leave a message for your future self or the next generation of trial attorneys, what would it be?
I think it would be get into the courtroom early, and if I had not done that, I think I was just too young and naive to realize how big the stakes are, and part of it, I guess, was starting out with kind of smaller cases. But as you get older, and the cases get more serious, if I had not had that background of going in and trying cases and becoming comfortable in front of the court, in front of the jury, and understanding all of the juggling that has to go on and the different plates that are spinning that you've got to keep going so they don't fall on the floor. It'd be very difficult to do it. And I don't know how, people that call themselves litigators or trial attorneys, you want to ask them, when's the last time you've had a jury trial? Because it's the jury trial, it's a dying art in many ways because the courts are forcing cases to get resolved. And they're either issuing motions or they're doing things to get it resolved. I happen to be at that point in life where I've done so many of them, I get called by other attorneys to come in and help them try a case. And I think that's simply because I did it early. So if you're a young attorney, you need to get in a practice that's going to let you go into the courtroom. And if you're in a gigantic law firm and you're representing a company on a $1 billion merger that's gone awry, you're likely not going to see the inside of the courtroom. You're going to be doing something very different. If on the other hand you said, "Gee, let me go take a year and go function as a prosecutor, or go to a firm where they are doing a lot of trial work, and you try and get in early," uh, that will benefit you for the rest of your life, for the rest of your career, because you just cannot substitute the actual experience with, pretending that you've got it or seeing it from afar. You've got to get in and suffer the knocks yourself to be able to succeed as a true trial attorney.
Perfect. If someone was looking to contact you for guidance, representation, what would be the best way to do so? Your website, your phone number?
Yeah, well, my direct dial, so they could call it 404-586-2020. So I always kind of say 404-586, then kind of perfect eyesight of 2020. Or the website, my email address is on the website. So it's just www.fellab, which is fellows LaBriola scrunched together. So FELLAB as in boy.com. And then within that, if you go to my bio, you'll then see I have a separate website that you can link to that goes through just the catastrophic personal injury and wrongful death cases. So that would be the easiest way to do it. I'm here in Georgia. So you go to any of the search engines and type my name up. There are not a lot of LaBriolas in Georgia.
Yes, sir. Mr. Labriola, this has been such a great conversation. You've really given us a window into what makes a great trial attorney, not just skill, but preparation, composure, and a real sense of purpose behind every case. Thank you so much for taking the time to share your thoughts with us today.
Sal, thank you for having me. I appreciate chatting with you today.
Thank you for listening to the Top Attorneys Podcast. The Top Attorneys celebrates the achievements of leading attorneys across the nation. To be featured, send a message or visit www.topattorneys.us.